Hello and welcome everyone to our webinar today on COVID-19 and its impact on IP practice in Canada. Today we're going to specifically be talking about the designated days and extensions of time that have been provided by CIPO, in particular in regard to patent prosecution in Canada. I note that this is a joint CIPO-IPIC presentation. Before we get into the presentation, first of all, my name is Patricia Falkins. And I have a couple of housekeeping notes that I need to share with you. First, please note that all participants' phone lines have been automatically muted to eliminate background noise. You are, however, invited to submit questions using the question box on your screen. The questions will not be visible to the audience. The panelists will verbally respond to the questions either throughout the talk or at the end, depending on time. So please don't wait to the end of the webinar to send in your questions, as we may run out of time. But if we do, we will get back to you after the talk via email. Next, in compliance with accredited provider rules, IPIC is required to issue a participation code during the webinar. The code will be announced at some point during this presentation. In order to receive your CBD attestation, there are a couple of things you can do. First, you will receive an email this evening. That is all participants, even those participants in groups. They will receive an email this evening with a link to request your CPD attestation. You will need to enter the code that is provided during the webinar, and as well, you will need to provide your email address. Alternatively, once the webinar is finished, you can go to IPIC's website at ipic.ca/attestation to complete your attestation request. Once submitted, you will have immediate access to your attestation by logging into your portal and clicking on My IPIC CBD Attestations. Finally, if you do require any assistance at any time during this presentation, please call the IPIC office at 613-234-0516, extension 27. Now, on the next slide, there's a list of your presenters for today. Very happy to have Craig McMillan with us today. Craig is the International Program Manager at the Canadian Intellectual Property Office. I'd like to just say, not only is it great that Craig is with us today to provide his much needed insights and expertise and answers from CIPO's perspective, I think his presence recognizes the established partnership between IPIC and CIPO and how well this partnership is working during this stressful time to balance maintaining the health and safety of everyone involved and balance that with maintaining strong protection of IP rights for all stakeholders. So thank you, Craig. Further, just a little bit more about Craig. He's worked at the Patent Office since 2003, and he spent just under 10 years as mechanical patent examiner before moving into the Patent Policy and International Affairs Division. There, he has worked on PCT issues, the patent prosecution highway, substantive patent law harmonization, and many other initiatives. Most recently, he led the project to amend the new patent rules, which came into force on October 30th, 2019. And on that point, some of you may recognize his voice from delivering a presentation about the new rules at the IPIC AGM in 2018. Next, our next presenter is Jenna Wilson, who again, I'm very happy to have here with us as a presenter. She is a partner at Wilson Liu LLP with a practice focusing on patent drafting and prosecution. Some of you know her as the lead of the patent group, the practice group of the IPIC Patent Committee, a role she has had since 2017, although with different titles. She participated in technical consultations on the patent rules in 2017 and worked on IPIC's response to the draft patent rules in the Canadian Gazette, and has had many enjoyable debates with Craig about the new act and the new rules during that whole process. Finally, as I mentioned previously, I'm Patricia Falkins. I am a partner at Breskin & Parr, where I am the head of the Chemical Patent Practice Group, as well as the chair of our Patent Practice Advisory Committee. I've been working in the area of patent drafting and prosecution in the chemical and life sciences area for over 20 years, both in-house and in law firm setting. I am the current chair of IPIC's Patent Committee. I'm relatively new to this role, and I have nothing but great respect for the depth of knowledge of my co-presenters. I'm very happy that they are here. So, just as a brief background to get into the substance of our webinar today, I think it goes without saying, we all know that times are very stressful and very unusual right now as there's a pandemic going on. And CIPO has certainly recognized that there's need to protect the health and safety of all people working in the IP field, in particular, obviously everywhere, but in particular, their interest is the IP field, both at the Patent Office and in our profession. Therefore, CIPO has made the following announcements concerning the IP deadlines falling on certain days. So on March 16th, it was announced by CIPO that for the purposes of subsection 78(1) of the Patent Act and the corresponding subsections of the Trademarks Act and the Industrial Designs Act, all days in the period of time beginning on March 16th and ending on March 31st, 2020 are going to be considered designated days. Now, of course, as March 31st approached and the pandemic was not abating, there was a need to make a subsequent announcement on March 27th that extended those designated days from March 31st to include the period of time beginning on April 1st and ending on April 30th, 2020. So we're going to be talking about these designated days and their implications. And in this webinar, this is just a brief overview of our webinar on this slide. Craig is going to begin by talking about CIPO's current operational status, and then we'll get into talking about Section 78 and trying to understand it and how it is applied to time periods in the Act and the rules. Then we'll talk a bit about what happens after the designated days when they're done, and requesting other alternative extensions of time. Finally, we will end by providing some of our recommendations regarding advising clients and safeguarding their rights as it pertains to these provisions. Hopefully at the end, we'll have some time for additional questions. So Craig, I'm going to put this over to you to get into CIPO's operational status. Thank you.
Thank you, Patricia, and good afternoon, everyone. I'd also like to start by thanking IPIC for inviting CIPO to participate in the webinar on extensions of time. It is always a pleasure to work with the profession on these kinds of issues, and it's a learning opportunity for us as well to see how your business is affected through these difficult times. This is an important subject, and we want to be sure that everyone understands it in order to avoid unintended consequences. So let's just start off by discussing what the current operational status is at CIPO. CIPO does remain open for business. We are operational at this time. However, the only service that can be conducted in person at CIPO is the delivery of mail. The mailroom at 50 Victoria and 235 Queen Street are accepting submissions into a mail drop, and this includes for any registered mail. We do have some temporary changes to the mailroom service hours. The mailroom is going to be open from Monday to Friday from 7:30 to 11:30 in the morning. It will be closed for an hour, and then it opens again from 12:30 to 4:30 in the afternoon. You should note, if you do attempt to go to CIPO to deliver mail, that at this time the payment of fees cannot be done on site. This was a service that was done at the Client Service Center, and the Client Service Center is closed at this time. If you do need to make a payment, you could provide payment instructions in your mailed submissions to the Patent Office and drop that off to the mailroom, or you could look at paying those fees online. Another thing to note in relation to correspondence is that the regional offices or the designated establishments, they are all closed at this time, with the exception of the Ottawa office at 235 Queen Street. And this includes the regional offices in Toronto, Vancouver, Edmonton, and Montreal. If you're considering submitting documents by registered mail or express post, we encourage you to contact Canada Post for updates on their current operations. We haven't seen this yet in Canada, but many other countries have suspended mail delivery, or there are significant delays in that service. Because of this, we're strongly encouraging people to use online services to submit correspondence to CIPO and to request that CIPO correspond with them electronically. This is because we're limiting the number of employees on site at this time, and using electronic correspondence will help us ensure the health and safety of our employees. So transitioning to that method of conducting business would be much appreciated during this period. Keep in mind, if you do online transactions with CIPO, that there are service interruptions at various times over the weekend. There is a website here that you can go to that lists when those maintenance periods will happen. These are just routine maintenance periods. They happen every weekend. And we would just encourage you to familiarize yourself with those periods and try to avoid them as much as possible. Patricia already covered the designated, sorry, yeah.
Craig, can I just interrupt for a second? I just have a question. Somebody's asked if faxes are being received at CIPO.
Faxes are currently being received, yes.
Okay.
Yeah, there's no interruption to that service right now.
Okay, thank you.
You're welcome. So the designated days, Patricia already covered this earlier, so I'll just note that the situation continues to evolve in a very unpredictable way, and the commissioner may decide to designate additional days beyond these periods if the need arises, but you shouldn't rely on that happening. So the deadlines are generally moved to May 1st. If you are able to act during this period, we would encourage you to act and not necessarily make use of the extension, but I wouldn't rely on having a further extension after May 1st. There is a link here to frequently asked questions. It's a page that CIPO created that deals with just some of the COVID-19 service interruptions. I would encourage you to read those. There's some good questions and answers in there. Also on our main page in the notices section, which is just at the very top of the website, that's where you're going to find the most current information on CIPO's services. And please check that area regularly for updates. I believe everything that we're talking about today is as up to date as possible, but by the end of the day, things could change as well. So that's the best place to look for the most up-to-date information. Regarding incoming correspondence, at this time, all paper and electronic submissions are being processed with no interruption to that service. To list a few examples, applications are being filed, payments are being processed, the Canadian Patent Database is being updated on schedule, and responses to examination reports are being sent to examiners. I will note there are longer delays in the processing of paper correspondence, and that's due to the restrictions on the number of employees on site at CIPO. So I'll say it again, corresponding electronically is really the best option right now if you want to reduce the chance of having delays. In terms of outgoing correspondence from CIPO, all correspondence is being sent with no interruption to that service. There was a 7 business day interruption to most outgoing correspondence between March 17 and 27, and that was because of IT issues relating to the designated days. That problem was resolved and service resumed on April 1st. Due to operational restrictions, as I mentioned, you might expect some kind of delays in receiving correspondence, including any courtesy letters that acknowledge receipt of documents or confirm that an action was taken. Currently, the document delivery service, which includes ordering of file wrappers and priority documents, is suspended until at least April 30th. It is planned for that service to resume on May 1st, and all requests will be actioned in order that they were received. So there is a queue of requests that is being maintained right now. If we look at other countries, probably most notably European countries at the moment, there is a risk that mail delivery could be impacted to the point of not being a reliable method to receive correspondence from CIPO. So to better ensure you receive that correspondence, make a request to CIPO to change your preferred method of correspondence from paper to electronic. You need to clearly request a change of method of correspondence to electronic. You need to provide us with an email address and list the applications and patents to which that request relates. This will help us ensure the health and safety of our employees, because paper mail requires employees to be on site, while electronic mail can be prepared and sent remotely to you. As I mentioned previously, most patent branch services are active at this time. Many examiners already worked remotely in a paperless way before the COVID-19 pandemic affected our ability to go into the office. So their work is continuing largely uninterrupted. Examiner reports are being sent, applications are being recommended for allowance, and examiners are available for telephone interviews. There was that interruption I spoke about previously in outgoing correspondence. That did include the sending of examination reports and notice of allowances, but again, that service was resumed as of April 1st, so all that correspondence is being sent. There's no major interruption at this point to the filing and the prosecuting of applications, and this applies to regularly filed Canadian applications and PCT applications entering the national phase in Canada. Also, any business in relation to PCT applications is uninterrupted, and that includes PCT applications that are filed with the Canadian Receiving Office, and also the applications that are processed by Canada as an international search authority or an international preliminary examining authority. You'll be glad to know that patents continue to be granted for the time being. However, the operational restrictions to the number of employees on site at CIPO has forced us to reconsider how we manage the granting process. So for example, we're starting to explore various options that would enable us to process grants remotely, including perhaps electronic grants. The Canadian patent database is up to date. It's being updated according to its regular schedule, so there's no delays there, other than the slight delay in processing incoming correspondence and getting it into the system. And a final note that the Client Service Center is functioning remotely still, even though you cannot go there in person. So agents in the Client Service Center are answering phone calls remotely at their house. They're returning emails, and any requests that are submitted to them online will be dealt with in the order that they get received. And finally, we'll talk about just some of the service interruptions and slowdowns. What services are affected? I'm happy to report that there are not many at this time. As many of you know, the deadline to renew registration on the Register of Patent Agents has been extended to May 1st. There are delays in getting out the confirmation letters, but if you do the renewal online, I think you do get a confirmation of payment right away. All Patent Appeal Board hearings are not being conducted in person at this time, but you can request that those occur by phone. Similarly, in-person interviews with patent examiners has been temporarily suspended, but those interviews can happen by phone. They were happening by phone more frequently prior to the pandemic. I imagine they'll happen by phone quite often after this. As mentioned, Client Service Center and Search Room at CIPO, at our offices in Gatineau, those functions are closed to the public, and the document delivery service has been halted until April 30th. So I hope that gives you a clear picture of CIPO's current operational status. If there are any questions at this time, maybe we can take those, and if not, then I'll pass things over to Jenna, who's going to unpack what exactly Section 78 of the Patent Act is doing.
Hi, Craig. Yeah, we do have a few questions that have come in. One specific question about what if they need to submit a certified copy of a priority document, how they should do that.
So at this time, the service is just not available. It has to do with how CIPO certifies the document and trying to maintain the service in other areas required that that service be suspended. I think there are extensions of time for most offices to supply that document. A notable exception would be probably in the US, where you have to supply that before grant. So if it's possible to delay paying the grant fee in the US, that would be something to look at to buy yourself some time to order the priority document if it wasn't already ordered, you know, when you filed the application down there. But this is evolving on a day-to-day basis. So I know for a fact that Business Services is looking to see if they can bring that service back online sooner than April 30th. Perhaps they might be able to bring it back online for critical cases, but as of today, it's just it's not available. It's just one of the impacts from COVID-19 at SIPO.
On a similar note, the question goes on, is there any work on making certified copies available on WIPO DAS or something similar?
Yeah, so SIPO has been looking at that for some time. As many of you know, we became an accessing office where we were pulling information from WIPO DAS. We are continuing to work on becoming a depositing office, but there's no date I can give you at this time for when that's going to happen. Obviously, that work has been slowed down by the COVID-19 service interruptions. The people that were working on that are working on making sure our systems are functioning. But this certainly does highlight the importance of having that that service available.
Agreed. Just one quick last clarification. So I'm not sure if that first question was meant, what do they need to do if they want to submit a certified copy of the priority document to you guys rather than get one from you guys? So if they wanted to.
So if they're submitting a document to us, there is no interruption in that service. So they can, I mean, they could submit it electronically even. They can submit it by mail.
Okay.
It's actually, I should say on that point, I mean, we did discuss that internally recently. We are allowing clients to submit certified electronic copies of priority documents where the copy that they're providing is actually a photocopy. So as some of you know, we're already accepting these by fax. And if they're submitted through the general correspondence webpage and it's, you know, it's a copy of a copy, we are going to accept that.
Okay, that's great to know. Okay, I will stop it now with the questions, and we'll go on to the next section with Jenna.
Okay.
Thank you.
All right, so Craig, if you could just advance one slide. Craig's in control of the slides. There, thanks. I wanted to start this segment by talking about the past because I wanted to highlight the changes between previous versions of Section 78 that a lot of us are used to and what we have now. So back in the time of the Great Flood, Section 78, and obviously this is 2017, that Great Flood, Section 78 just referred to indiscriminately extending time limits and limitation periods whenever the Patent Office was closed for business. And subsection 2, as you all remember, it itemized those days that were scheduled closures, Saturdays and holidays. And it did provide that the minister could make a special order declaring the Patent Office closed for business. And subsection 3, if there was a special order, subsection 3 required that that order be published in the Canadian Patent Office record. And I'm actually going to be referring to that much later in this webinar. But anyway, that's a previous version. Thanks. There's our no longer enforced stamp. So next slide, please. Right, and then there was another version that came into force on September 21st, and this was at the time of CETA implementation. And note there was the addition of a restriction in respect of any business before the Patent Office. That limitation wasn't there before. And of course, the changes that happened in 2017 included the addition of the Certificate of Supplementary Protection provisions, which is a procedure that doesn't actually involve the Patent Office, that involves Health Canada. So there was some logic to adding that restriction at the time. But this is no longer in force either. So click, Craig, thanks. And to the next slide to just sum up what this means. And the reason why I'm bringing this up about old Section 78 is that there are a couple of quirks. And one was that emergency relief from patent deadlines was only available back then if there was a special order declaring that SIPO was closed for business. And that's what happened in May 2017 with the flood. But SIPO could not remain open for business and grant this kind of relief from deadlines. So if it was the case where applicants from outside Gatineau needed emergency relief from deadlines, but SIPO was perfectly operational, that was just too bad for all those other applicants. And in fact, IPIC had lobbied for an amendment to address the situation for years. And this was actually added in the form of current Section 78 in the 2015 package of amendments to the Patent Act. But of course, that didn't come into force until November 5th, 2018, along with similar amendments to the Industrial Design and Trademark Acts. The other point I want to make about a quirk in old Section 78 is that it did identify holidays as dates when the office was closed. And those holidays were not actually defined in the old Patent Act or rules. So we would have to refer to the Interpretation Act to figure out what they were. And the Interpretation Act defined a holiday as including official federal and provincial holidays. But of course, it didn't force a federal government office to respect another province's holidays. And that's why, of course, CIPO, being based in Quebec, is closed on June 24th, while the rest of the country is open, so we all get a little break from deadlines that day. But conversely, CIPO is open on Family Day because that's a provincial holiday that does not exist in Quebec. So those of us who do have that holiday, we still have to make sure that we meet those deadlines. But it was that combination of old Section 78 referring to holidays and Section 26 of the Interpretation Act that enabled a trick that a lot of you are familiar with, which is that you could file in a regional office and basically get an extra day. Because CIPO has regional offices in other provinces that close on their own provincial holidays, as long as you filed on paper in that province's regional office, you could choose to file your correspondence on the day after their provincial holiday and you would still meet your deadline. And that's a cute trick. But the reason why I'm actually going over this right now is to tell you that this has changed with current Section 78. So next slide, please. There, and the next one. All right, so here is our new current Section 78. It looks superficially similar, but it's not. So we no longer have any mention of holidays, and we no longer have a mention about deadlines being extended just because the office is closed for business. Instead, 78 sub 1 now says that if a qualifying due date falls on a prescribed day or on a designated day, then the deadline is extended to the next day that is not a prescribed day or a designated day. And subsection 2 allows the commissioner to designate a day for the purpose of subsection 1. So we don't actually need the minister anymore to make any order. And this means that the commissioner can also declare emergency relief without actually having to close the patent office. The next slide, please. So in this discussion right now, what I'm going to talk about, I'm going to focus on the meaning and the effect of prescribed and designated days. There are, of course, a whole lot of other terms in Section 78 that need analysis, but Craig is going to address that shortly. So moving on to the next slide. It's easy to find, next slide, Craig. Thank you. Most prescribed days are easy to find because they are actually spelled out in the patent rules. And what's notable here, of course, is, and we've already experienced this, the first Monday in August is now a prescribed day. So our deadlines falling on that first Monday in August are extended, even though CIPO is actually open for business on that day. But yeah, Family Day is still not a prescribed day. Note that paragraph N also defines as a prescribed day any day that the patent office is closed to the public for all or part of the day during ordinary business hours. So if there is an unscheduled closure of the patent office, say for example, if there's another flood, then it is actually a prescribed day, not a designated day. Next slide, please. So like I said, if there is an unscheduled closure, it's a prescribed day. On the other hand, a force majeure event that results in that doesn't actually require the office to close, but if the commissioner finds it's in the public interest to grant relief, then that would be a designated day. And prescribed and designated days actually have the same legal effect on deadlines. It doesn't matter whether the day is prescribed or designated. All that really refers to is how the day came to have this effect in subsection 1. So this actually addresses the first quirk I talked about, in that the Patent Office doesn't actually have to be closed to grant extraordinary relief from deadlines. The next slide. But this new section 78 also puts the kibosh on that second quirk that I talked about, where you could get an extra day for your deadline by filing with a regional office, because section 78 no longer refers to holidays, but instead, in combination with Rule 5, expressly defines how a deadline can be extended and which special days will create that extension. So because of this, SIPO takes the position that this regional office loophole is no longer available because there is no need to resort to the Interpretation Act to fill any gaps in the Patent Act concerning deadlines. And personally, I think I'm about 90% on board with their interpretation. So we'll go with that. So the moral is really that designated establishments, regional offices, are not quite as useful as they used to be to us under an earlier version of Section 78. So on the next slide, I've got a graphic illustration of the effect of Section 78. And this is just to illustrate that it really doesn't matter to your deadline whether or not your local designated establishment is open or closed. Your deadline is your deadline. What affects your deadline and what determines whether or not it's going to be extended is whether or not it's a prescribed or designated day. And that can include whether or not the Patent Office is open or closed. The next couple slides show the effect of designated establishments on communications. Rule 10 makes it really clear that it's the status of the Patent Office being opened or closed, and not the regional office that determines when your correspondence is deemed received. And the next slide just emphasizes this point again. Not only is it in the interest of SIPO employees and their health that you file electronically, so by fax or by e-filing, but Rule 10 itself really favors electronic delivery, because as long as the SIPO fax bank and servers are still working, the date of deemed receipt of your correspondence will always be the day it was actually received, even if SIPO is closed. And this is actually going to be important when we talk about third-party rights. So one last note, in case you didn't realize it, and I'm sure you have all noticed it by now because you would have received some sort of correspondence like this, the Patent Office now automatically calculates extended due dates under Section 78 and prints them on form letters. So here's one example. I've circled the filing date and the computed maintenance fee due date, which was adjusted due to Section 78. And the next slide is an example of a late maintenance fee, showing that the late maintenance fee due date was also adjusted under Section 78. And of course, for a while now, on the next slide, we've seen the automatically calculated due dates on the admin status tab in the online database. All those maintenance fee due dates already take prescribed days or designated days into account. So now we can turn it back to Craig to talk about actually applying Section 78 to due dates in the Act.
Thank you, Jenna. In this part of the presentation, I'm going to speak about which time periods are and are not extended under subsection 78(1) of the Act. Jenna spoke about this briefly in a previous slide, so I'll point out that most time periods in the Act and the rules do get extended under subsection 78(1), with the exception of time periods that are not for taking an action and that are not for doing business before the Patent Office. So just some notable exceptions here are any deadlines in relation to a CSP are not extended under subsection 78(1) because that is not business before the Patent Office. The grace period for pre-filing disclosures, it's not a time period for doing something. So CPO's position is this is not extended either. In that case, the time period referred to in the Act is a time period within which the pre-filing disclosure will not be considered for the purpose of novelty or obviousness. So arguably, there is no action being taken in that moment. Okay, let's look at some time periods that are extended under Section 78 of the Act. The application fee still has to be paid on the filing date to avoid the late fee, but it is not, if it is not paid and a notice is sent requiring that it be paid along with the late fee, the deadline in that notice is extended. Other time periods related to the filing of applications, such as the deadline to submit missing filing requirements, deadlines to submit translations, the addition of missing parts, and reference filings, those are all extended. There are some limitations to extensions related to the addition of missing parts and reference filing, and I'll get into those in a few slides from now. The 18-month publication itself is not extended, and during the designated days period, applications continue to be laid open to public inspection, so that's important to know. That said, the 16-month deadline to withdraw the priority claim and to withdraw the application to affect the publication, those are extended up to a maximum of 18-month publication, and I'll again explain that in a couple slides from now. Request for examination. So the 4-year time limit to request examination is extended, and for applications that are filed before October 30th, 2019, where the old rules applied, the 5-year time limit to request examination is also extended if it falls during this period. This slide is dealing with most deadlines in relation to priority claims. So for nationally filed applications, the 12-month priority period is extended under subsection 78.1. It's important to note that that is not the case for PCT applications. For the priority period to be extended for PCT applications, the office would need to be completely closed for business in accordance with the Paris Convention and Rule 80.5 of the PCT. So if you are filing a PCT international application in Canada, please note that. I won't go into all the details here on this slide, but I'll just state that if a deadline is in relation to a priority claim, such as the deadline to request priority or to provide documents, it is going to be extended. Okay. Regarding prosecuting the application before the office, all deadlines are extended. So this includes deadlines in examiner reports, in compliance notices, the deadlines to pay maintenance fees on applications and patents, deadlines to reinstate an application, deadlines to reverse the deemed expiry of a patent, and also the deadline to pay the final fee. For returning an application to examination after it's been allowed, the 4-month deadline is extended. However, of course, if you pay the final fee, you could no longer request the notice of allowance be withdrawn to return that application to examination. Many of the deadlines related to administrative matters are also extended. So for example, as mentioned earlier, the deadline to register your name on the Register of Patent Agents. If your client receives a notice to appoint a patent agent, the deadline to appoint is extended. In relation to PCT applications that are entering the national phase, most of the deadlines here are extended. I'll note that there is a mention here on the slide of reinstatement of rights when entering the national phase in Canada after 30 months from the priority date. This is extended under subsection 78.1, but it only applies for applications with a filing date on or after October 30th, 2019. So it's completely irrelevant to the current situation, and it won't be relevant until 30 months after October 30th, 2019. Importantly, the deadline to file a divisional application is extended, but only when the original application is refused. So the divisional needs to still be filed before the original application is granted. And at this time, CPO is continuing to grant patents. So be aware of that deadline if you're intending to file a divisional. Finally, for patents, the correction of errors provisions that have a deadline of 1 year after the grant of the patent, those are extended. The deadline to request reissue is also extended. And once reexamination has been requested any deadlines in relation to those proceedings also benefit from the extension under Section 78. An important point I want to make, just because so many applications are in the system that have been filed before October 30th when the new rules came into force, is that all the extension of deadlines that we just discussed, those are applicable also to the pre-October 30th applications if the deadline applies to those applications. So the most important ones perhaps for you are deadlines in relation to prosecuting the application, such as deadlines to respond to examiner reports and deadlines to pay maintenance fees. I received a notice on my screen that I may be experiencing network connection difficulties. Can someone just confirm that I'm still on the air?
I can still hear you, Craig.
Okay, thank you, Jenna.
It's Patricia, but that's okay.
Oh, Patricia, sorry.
No worries.
Okay, so I mentioned previously there were some limitations to some of the time extensions that are available. In relation to publication, generally the time limit to withdraw a request for priority is 16 months after the earliest priority date. That is going to get extended out to a maximum of 18 months when publication would occur. The same in relation to the time limit to withdraw an application to stop that application from laying open. Applicants will have up to the 18-month mark to try to stop the or to request that the application be withdrawn to stop publication. But there are some practical limits here. So if the designated days do kind of extend towards that 18-month mark, obviously if there was a request that was submitted in the waning hours before the publication, SIPO is not going to be able to stop the technical preparations to lay that open. So the time limits relating to the addition of missing parts, they also have limitations. Whether it's the commissioner that notices something might be missing in the application or the applicant that notices that something's missing, the time periods for addition can be extended up to 16 months if the deadline falls on one of the designated days. If these deadlines are extended during the current designated days period, the applicant, of course, will need to comply on the next day that is not a designated or prescribed day. So it's not automatically extended for 6 months. It's just extended to the next day that is not designated or prescribed, which is expected to be May 1st. And just to note that if the addition will affect the filing date, applicants can withdraw the addition to maintain the original filing date. And I just wanted to point out here that there is a 2-month deadline, and there is no limit to that extension during this designated days period. Now, there are some important time periods that are not extended. So SIPO's position is the grace period is not extended. If there has been a public disclosure of the subject matter of an invention, SIPO recommends that every effort be made to file the application within the 12-month grace period. And that should be calculated without reference to any prescribed days or designated days. So we're strongly cautioning applicants from relying on subsection 78.1 to extend the grace period. The limitations set out in subsections 36.2 and 36.2.1 of the Act requiring that a divisional application be filed before issuance of the original application is not subject to an extension under subsection 78.1 of the Act. So something to be aware of. Time periods for appeals, they are not extended. These are not time periods in relation to business before the Patent Office. One exception here is SIPO is taking the position that section 4 of the patent rules does actually extend the deadline under section 18 sub 2 by extending the period to request the extension of time in 18 sub 2. So extensions to the time limit in 18 sub 2, they're only available for appeals that have a 3-month deadline. Appeals with other deadlines are not going to be extended. So probably most notably is the appeal under section 40 of the Act. Also remember that extensions in Rule 4 have to be applied for before the original time limit expires. So that does not get extended. So you need to apply before the 3-month deadline. Lastly, SIPO's understanding is that extensions available under Section 78 of the Act in relation to designated days have no effect whatsoever on international procedures under the PCT. So with this understanding, these time periods are not extended as a result of the designated days. Time periods related to PCT applications in the international phase may be able to be extended under provisions in the PCT. So for example, and probably relevant to the current situation with the pandemic, is extensions under Rule 82 Quater. If there is an inability to take an action and it's related to the COVID-19 pandemic, you might be able to seek relief under this provision. WIPO prepared a pretty good outline of extensions available for PCT applications. That was published in the March edition of the PCT newsletter. If you do a Google search, you could probably find that pretty quickly. That's a worthwhile read if you need to rely on an extension of time during the international phase. Okay, next up, Patricia is going to talk about what happens on May 1st when the designated days period is over and what's next.
Thanks, Craig. Before I do that, I'm going to give you your CBD code. So in compliance with CBD accredited provider rules, IPIC is required to issue a code during the webinar, and this code is DD1920. Again, the code is DD1920. Okay, to give Jenna and Craig a little bit of a break, I'm going to talk about what happens when these designated days end. So Craig, on the next slide. Of course, we need to turn your attention to responding to those due dates. As previously mentioned, deadlines falling on or between March 16th and April 30th, 2020 have been extended to May 1st, 2020. So we think about it as like a really long weekend. If, however, that action that needed to be taken on or before May 1st doesn't happen, or you don't meet those due dates, what will result? And that depends on what the due date was that you missed. So for example, if the due date was to respond to an examination report or pay a final fee or respond to a late notice, if that isn't done on or before May 1st, then that application will be deemed abandoned. However, if the due date was to pay a maintenance fee or file a request for exam, then the application will not automatically be abandoned. As we know under the new rules, the Patent Office will send out a late notice setting a new date for response that's calculated based on the extended date. We have to be very careful about the first circumstance where if you don't respond by May 1st and your application goes abandoned, you've got to keep in mind that even though the application can be reinstated within 1 year, some of these requests for reinstatements will require that the patentee or the applicant provide reasons that the due date was missed despite taking due care. And of course, we know that is something we want to avoid. And that is, for example, if you miss due dates for responding to late notices, for failing to pay the maintenance fee, or for requesting examination. It's important to note that the due care provision starts on May 2nd. That is, if you don't pay something on May 1st and you want to reinstate on May 2nd, then that's when you may need to provide reasons of due care. And it's kind of interesting that the new rules came into effect on October 30th, 2019. So the earliest 6 months past that is April 30th, 2019. So the first day that anyone could have requested reinstatement based on due care was indeed May 1st, but that's now been extended to May 2nd in view of the designated days. So as mentioned previously by both Craig and Jenna, where applicants are advised not to wait until the last minute to submit time-sensitive communications. And once the designated days are over, of course, the office will continue to send late fee notices and courtesy abandonment letters as per usual. So in terms of reinstatement, Craig, on the next slide. There we go. If your application has unfortunately gone abandonment, you have to consider what you need to do for, what you can do for abandonments in view of the designated days. And basically can kind of divide this analysis into whether or not your application was currently abandoned during the designated days or was abandoned as a result of missing the May 1st due date. So in the first scenario, for applications that are currently abandoned that had a reinstatement date following during the designated days, the reinstatement deadline is computed as the next day that is neither a prescribed day or a designated day, and that is currently May 1st. One example of this shown on the slide, and it's actually answering a question that came in to us through IPIC, is of a Category 3 application that received a notice of allowance on October 15, 2018. The final fee for that was due April 15, 2019. And if that date was missed, then the reinstatement due date was April 15, 2020. Of course, that is being extended to May 1st, 2020 because of the designated days. Note that the applicant may reinstate by May 1st, and they may also file an amendment after allowance and put the application in for further examination if desired, and that's as a result of the transitional provision of Section 78.51 of the Patent Act. So on the next slide, it's the case where the application was in good standing and the due date was May 1st and it was missed. So they will be deemed abandoned if the action is not taken by May 1st. The reinstatement deadline is 12 months after the deemed abandonment, so currently 12 months after May 1st. But note the reinstatement deadline is also subject to subsection 78.1, so there can be some stacking of extensions of time, and I'll go over a couple of examples here. So the first example is if there was an examination report mailed on November 18th, 2019. Under the new rules, you have 4 months to respond to that. So the original due date is March 18th, which now is extended to May 1st. If that response is not filed, the reinstatement due date would be May 1st, 2021 under the current designated days. But May 1st, 2021 turns out to be a prescribed day. It's Saturday, so the reinstatement due date is extended to May 3rd, 2021. A couple of other examples on the next slide. Craig? Okay, there we go. Another example, if a maintenance fee was due on October 31st, 2019, this is under the new rules, and it's not paid. And then there was a late fee notice that set a deadline of maximum 6 months to April 30th, 2020 to pay. The late fee due date is obviously extended to May 1st. And the reinstatement, the reinstatement, the date 1 year, 12 months from that date would be May 1st, 2021. And again, this would be extended to May 3rd, but remember that the due care requirement will apply. So one more example, again, of a final fee payment. It's a Category 3 application that received a notice of allowance mailed October 15th under the old rules. So the due date would be April 15th, 2020, extended to May 1st, 2020. If that final fee is not paid on May 1st, the applicant may still reinstate up to 12 months later to May 1st, 2021. And again, there's some stacking of extensions of time to May 3rd because of May 1st being on a weekend. Under this circumstance, the applicant may still file an amendment for further examination if desired, as per subsection 78.521 of the Act. Okay, on the next slide, I believe we're going to talk about different mechanisms, further mechanisms for requesting additional extensions of time. And on the next slide, many of us know that additional time to act may be available by requesting an extension of time under Rule 3.1. But we have to keep in mind that there are certain limits, certain deadlines where this will not apply or cannot apply, or there's some limitations on how we apply this. And one example is a response to an examination report. According to Rule 131.2, this due date cannot be extended beyond 6 months from the date of the notice. So there are some limitations to the amount of extension under Rule 3.1 that can be afforded to this type of due date. I think currently, I mean, this will depend upon when the date is, what the date is on the office action, but I think under current circumstances, there may be extensions of time to about 2 weeks to up to 2 months, again, depending upon the date on the office action. So this still may be worth it, worth requesting if, particular under these circumstances when it may be difficult to get instructions. Please keep in mind requests must be made prior to the expiry of a time limit, and the Patent Office will assess the requests, and if it's compliant and reasonable, it will generally be granted for a period of time of up to 6 months per file per action. So what about additional or second extensions of time on the same matter? This is on the next slide. So subsequent requests for an extension of time for the same action on the same file will only be considered under exceptional circumstances according to MOPOP. So I guess the question is, will this directive, i.e. the exceptional circumstances requirement, be relaxed during the period of COVID-19 disruptions? For example, will an extension of time be permitted if an applicant seeks a second extension of time under subsection 3.1, either during this period or shortly thereafterwards? So to try to answer that question for you on the next slide, as previously mentioned, there are certain deadlines, such as the deadline for responding to examination report, where no subsequent extension of time is possible for the same action. So this is not possible for filing a response. For all other deadlines, subsequent requests for an extension of time for the same action on the same file will be considered under those exceptional circumstances. Well, what is an exceptional circumstance? We look to MOPOP, and those are defined as those beyond the control of a person concerned and include, for example, severe illness, accident, death, bankruptcy, or other serious and unforeseen circumstances. So CIPO's response to this, I believe, is on this slide. COVID-19 disruptions occurring during the designated days period and thereafter will be considered to be an exceptional circumstance that may justify a subsequent extension of time, according to CIPO. So a simple justification explains why the subsequent extension of time is being requested must be provided, and the commissioner will analyze this and consider this on a case-by-case basis, and they must be satisfied that the particular circumstances justify the extension. But we must caution you that the applicant should not necessarily rely on the conditions that gave rise to the previous extension of time for their subsequent extension of time. So I believe that's all that I have, and we're going back to Jenna.
Right, thanks. So I've got a small handful of topics I want to cover on the subject of advising clients and safeguarding a client's rights, because the effect of having this extended period of designated days has a potentially deleterious effect on some things. So the first issue is, advising your clients, when should you actually take an action? And it bears repeating again. I think you've heard it about 3 times already during this webinar. If you've got instructions, if you're able to, take your action now. Don't wait until May 1st, and preferably file electronically for the reasons given earlier. And another thing to keep in mind is if you are in the habit of filing with a regional office, don't assume that your regional office is actually going to be open on May 1st. The decisions to open or close are made individually, and just because the designated days are ending on April 30th doesn't mean a regional office closure will be ending on that day. So you might need to make some alternate plans. Now, the next thing I want to talk about is grace periods and public disclosures. And of course, Craig covered this with the office position. And the office position is that grace periods are not extended by Section 78. And this is where the history of Section 78 comes into play again. And on the screen, I've got the language of the immediately previous Section 78 from September 2017 and the current one. Note, there is a change in language here from time limit or period of limitation to just time period. Is that narrower? Back up, please, Craig. Thank you. Is that narrower than the previous wording? Well, to me, a limitation period that's fixed under the Act is still a time period fixed under the Act. So arguably, there's no change there. Now, I don't actually have a slide here calling this out, but when I was talking about the history of Section 78, I also told you that the 2017 amendment also added the words in respect of any business before the Patent Office. So even if a limitation period is still subject to Section 78 today, it has to be in respect of business before the Patent Office. Now we can go to the next slide. And as Craig said, Section 78 doesn't apply to grace periods for disclosures, but the office position is that it does apply to the definition of a claim date. And so we could compare the wording of these two provisions to see what the difference really is. So what we have here is anticipation and the relevant part of the claim date provision. So Section 28.2 says that the subject matter must not have been disclosed before the 1-year period immediately preceding the filing date. And 28.1 refers to the filing date of your application being within 12 months after the filing date of the priority application. And these are both, you could say that these are both sort of limitation periods that are being triggered by an external event. In the case of 28.2, that event was a public disclosure that probably had nothing to do with the Patent Office. And I suppose the public disclosure could have been the result of the publication of an earlier Canadian application, but usually when this comes up, it's a commercial public disclosure. And in the case of 28.1, the triggering event was the filing of a priority application somewhere. It could have been Canada, it could have been another jurisdiction. The only real difference to my eye right now when I thought about this, and I haven't thought about this for very long, is that the wording of 28.2 is very passive when it expresses the activity that the applicant had to have taken in the Patent Office within their limitation period. 28.1, on the other hand, is more explicit about the action that the applicant had to take within 12 months. So what I'm saying here is you can see arguments both ways for interpreting Section 78 as applying or not applying to these provisions. And of course, we know what CIPO's position is. So next slide. Obviously, the best approach is to just assume, first of all, that grace periods are not extendable under Section 78, consistent with the office's position. File your application so that you actually meet the statutory bar deadline. And it's also best, although I don't actually have it on this slide, to treat your convention priority deadlines the same way. That being said, what would you do if a client came to you on May 1st and told you that they made a disclosure just over a year ago? Or even what if they came to you today and said, hey, I made a public disclosure on March 17th, 2019. Are you going to tell them that they're out of luck, or are you going to warn them about the possible risk of invalidity and file anyway? And this could depend on the client's appetite for risk and having to spend money. But if they were willing, I guess I would be inclined to warn them about the potential consequences and prepare them for, have them file an application and prepare them mentally and financially for getting a rejection and a refusal and having to appeal to the federal court to actually resolve this. Another thing I want to talk about on the next slide is third-party rights. And SIPO does not take a position on third-party rights because, of course, this is something that happens after patent grant and it impacts enforcement of the patent. And I'm not going to talk about the scope or the meaning of third-party rights, but what I'm going to talk about are calculations of the start and end dates in Rule 128. And there's a wrinkle that you need to think about because it turns out that it's probably not a good idea to take advantage of extended due dates for maintenance fees, for example. So next slide, I am just reproducing some of the language of Rule 128. So for this example, we'll just ignore requests for exam for now. We'll just consider the case where an applicant pays a maintenance fee and they pay it late, but the application remains in good standing and it's never deemed abandoned. So we're taking the case where the applicant chooses to pay their maintenance fee and late fee right on their 6-month late fee deadline. So the preamble of paragraph 128A says that the period of third-party rights starts beginning 6 months after a day on which a prescribed fee, I got a typo there, that should be fee, not free, referred to in subsection 27.1 sub 1 was due, I'm also missing another word there, due under that subsection, but was not paid without taking into account subsection 27.1 sub 3. The end date is the earlier of the date on which the maintenance fee and late fee were actually paid and the day of patent grant. So I'm going to try parsing these definitions on the next slides. So let's start with the next slide. And we're going to assume, first of all, that we live in an ideal world with no COVID-19 and no designated days. So in this case, the anniversary date, let's say it was Tuesday, March 17th, 2020, and the applicant doesn't pay their fee. Instead, they delay and they pay their maintenance fee and their late fee on September 17th, 2020. So your application remains in good standing. It isn't deemed abandoned because you paid the fee in time. And in all of these examples I'm talking about, this is always the case. Application does not go abandoned. So first, the third-party rights start. Again, I've got this typo about free perpetuated through these slides. Whoops. Third-party rights start 6 months after a day on which that maintenance fee was originally due. So we can parse this. So click once, Craig. Thank you. So if we parse this, well, the day that the maintenance fee was actually due was Tuesday, March 17th. And so we're looking at 6 months after Tuesday, March 17th. And I've applied subsection 27, sub 4 of the Interpretation Act to do this calculation to arrive at September 18th. So the logic is this, right? If you were to say the day after Tuesday, March 17th, well, that's actually March 18th. The point is the third-party rights should start after, in this simple case, after the applicant had missed their chance to pay the late fee in a timely manner. So what about the end date? So click again. The end date, waiting for it to appear. Craig, did you click?
It is clicked. It's appearing on my screen.
Okay, there it is. Okay, we got it. So
there is a slight delay between clicking and when it appears.
Okay.
Sorry.
So third-party rights end on the day that the fee was actually paid, which in our example is September 17th. So Craig, click again. And maybe I'm the slow one. I don't know. So in other words, there are no third-party rights because the third-party rights period ended before it could even begin. If you try a different interpretation of the start date, like you said, it was September 17th, then actually there would be 1 day of third-party rights, which is odd. So following this interpretation, let's go to another example on the next slide. So in our reality, actually, we have a whole lot of designated days. And it should have been March 16th through April 30th. You know what I mean? It's for the purpose of this example, okay, it's good enough to say that March 17th and through April 30th were designated days. So the anniversary date again was March 17th, but now because of the designated days, the maintenance fee could have been paid by May 1st. And this is due to the effect of 78 sub 1 on the maintenance fee provision. In this case, the applicant is cautious and they pay their maintenance fee and late fee electronically on November 1st. And I make the point about electronic because November 1st, which is 6 months away from May 1st, is actually a Sunday. So when we parse the start date of third-party rights, Craig, please click. 6 months after Friday, May 1st. Why? Because the day that this maintenance fee was actually due under subsection 27.1 sub 1 of the Act was in fact May 1st, not March 17th. Now, what about the end date? Click again, please. It's the day that the fee was actually paid, which, if we click again, that shows you that it was November 1st. So again, no third-party rights. Now, I've got 2 more examples. So we move on to the next slide. Now, let's consider the case where we have the same applicant whose due date for paying the maintenance fee was pushed off to May 1st, but the applicant, realizing that November 1st is a Sunday, says, hey, I'm entitled to actually pay my maintenance fee and late fee on November 2nd. And they choose to do that. Well, let's work through the calculation again this time. So the third-party rights start 6 months after the day on which the fee was due. So click, Craig. Again, it's a start date of November 2nd, just like the calculation of the next slide. Okay, now what about the next date? Okay, the day the fee was actually paid was November 2nd, same day. So we click through. So what we have here is a case where apparently there is 1 day of third-party rights, because the applicant decided to rely on the extended late fee due date. Unless you think this actually only impacts designated days, I've got 1 more example here, which is just based on prescribed days in Rule 5. So consider the case where the anniversary date is June 24th. Well, that's a prescribed day. So you could actually pay your maintenance fee on June 25th. But the applicant chooses not to do it. 6 months after June 25th is December 25th, but that's another prescribed day. And under Rule 5, the effect is that Monday, December 28th is also prescribed. So the actual effect of this on section 27.1 subsection 3 is that the late fee could actually be paid by Tuesday, December 29th. And let's say the applicant does that. So what happens to their to their third-party rights here? So we click through. The third-party rights begin 6 months after June 25th, which is December 26th. And the point here is we're calculating 6 months after June 25th, but subsection 78 sub 1 of the Act does not actually apply to extend the start date of third-party rights in Rule 128. And why? Well, it does not appear to be a time for doing anything before the office. All of this 6 months really does in Rule 128 is provide a calculation basis for the start of third-party rights, which has nothing to do with activity in the patent office. And what is the end date? Click once more. Well, it is Tuesday, December 29th. So in fact, an applicant who stood on their rights and took advantage of all of these extended dates could actually wind up inadvertently creating third-party rights based on, this is, granted, this is my interpretation of Rule 128, and this is, of course, something that is going to have to be looked at by a court at some point in the future. And of course, you can move on to the next slide. This applies also to late requests for examination and late patent maintenance fees. And the moral of the story is that it does seem to be safe to pay a maintenance fee by its extended anniversary due date, but it doesn't really seem to be quite as safe if you decide to pay the late fee by its extended due date, because you're not postponing the start date of third-party rights using Section 78. And on that note, I've got a couple more things, and I think we do have a little more time left before we can move to questions. One point I wanted to make, and it actually ties into the discussion about grace periods and claiming priority and third-party rights, is think about documenting the extended due dates resulting from designated days in your application files. The current Section 78 only requires the commissioner to inform the public about a designated day on the SIPO website. And it doesn't actually say anything about informing the public about a business closure anywhere. By contrast, previous 78 sub 3, which doesn't exist anymore, required publication of closure dates in the Canadian Patent Office Register. And that was a useful thing because the CPOR is an official record. It has an ISSN, it's preserved for posterity. So Section 78 as it currently stands doesn't actually give us the same comfort that there will be an official record that will live on in the future, that will be properly preserved, that everyone can refer to say, oh yes, I remember those were designated days. Sure, it's published on the website, but websites are ephemeral in nature, or so Canadian patent examiners keep telling me when they see URLs in my descriptions. And, we don't know what the SIPO website will look like in 10 or 20 years' time. And this could be important in the future, confirming whether there were designating days, confirming whether or not a late fee or a maintenance fee was timely paid, confirming that an applicant was entitled to file an application claiming priority to a prior application that had actually been filed 13 months ago. You're going to want to have something to refer to so that people who are inspecting your file wrapper in the future can verify that you do have the correct claim date or you do have the correct payment dates. Next slide. So what you can do is consider documenting these days, as I said. If you're taking advantage of a designated day extension, include a note to that effect in your submission saying what the designated days are. So it's self-serving, but at least it's documented somewhere so people know where to look. I think we need to go back a slide, Craig.
Sorry, are we on the right slide?
Now we're on the right slide, yes. Now we're back too far. Okay, I'm talking about slide 61. There we are, okay. So one thing you can do, like I said, is put in a self-serving comment in your submissions. That's not always possible. Say if you're actually paying a maintenance fee using the online system, all you're really doing is just adding a maintenance fee to your shopping cart. Something else to do is to print out and preserve a copy of the commissioner's designation from the SIPO website. Save it centrally in your system, save it in each file where you're actually taking advantage of the Section 78 extension so that you do have it to refer back to in the future. You don't have the same concern about documenting most prescribed days because most prescribed days are actually written out in the patent rules. So someone would always be able to go back to the patent rules that were in force at the relevant time to confirm whether or not a particular date was prescribed. The only prescribed days that you do have to be careful to to document in that case are the unscheduled closure days. So for example, if there was another closure due to a flood, which is probably due sometime next month in the National Capital Region. For future reference, in case you didn't catch it when it was first published, the slide shows you the citation for the official notice of the Patent Office, the CIPO closure in 2017 due to the flood. One last note about safeguarding rights and advising clients. There could actually be some other unexpected consequences that we haven't caught yet. And these are consequences that could result from just plain old normal prescribed days, but they're really magnified by having an extended period of designated days. And one of the funny results that I noticed was if you had a patent that was in about to lapse date last year as of coming into force that had an anniversary date during this designated day period, well, if you were waiting for that patent to expire, for example, if you're trying to advise someone on non-infringement, you actually have to wait a little longer because the term of that type of patent is actually governed by the previous Section 46, and the term, the expiry date for that patent would be determined by old Schedule 2. So I've got the thought process and the explanation there on this slide. I won't talk through it, but the point is that the funny result is that you might actually find that some patents have another 6 weeks of term that you aren't expecting them to have. And that's it for me.
Okay, great. Thanks, Jenna. Thanks, Craig. We have a number of questions that I could ask you. We have, I think, 8 minutes left. So I'll go through them as quickly as I can. We have 2 questions that are asking for clarification about the regular convention application filing date and the national phase entry application filing date. They want confirmation that the 30-month PCD filing date can be extended. So it seems that there's they just need someone to go back over that.
Sure, I can take that. So for applications that were filed internationally before October 30th, 2019, there is still a 42-month as of right national entry. So anyone who is entering the national phase right now during this period, or that might enter on May 1st, they're still well within that that period. So there is no need to rely on an extension of time there. I think that answers the question. But regardless, the 30-month deadline is extended. So you wouldn't even need to use that as of right period.
I think they're looking for confirmation that that 30-month date is extended. So that is good. Another quick question. Sorry. Okay, thank you. Will special order or / expedited prosecution status be lost if an extension is taken until May 1st? That's a question we have.
It's not something we've discussed internally in the office. Strict reading of the rules is yes. If you do request an extension of time under 3.1, you will lose the special order status. If you take advantage of the extension that's available under subsection 78.1, you will not lose it. So we would encourage you to do that rather than request an extension. And then, of course, as Jen had mentioned and I had mentioned previously, if you can act without needing an extension, that's always the best option.
Okie dokie. Do have one question that came in before the webinar, and that is, will the office reconsider its policy against accepting digital signatures, such as e-signatures or digital signatures, In particular, they would like comments on DocuSign, Adobe Sign, and Synography. Sonography. So Craig, I don't know if you could comment on that.
Sure. So we did decide. I mean, this is a perennial issue. We've talked about the digital signature issue with HIPIC many times. Due to the operational restrictions that have been caused by COVID-19, there's an increasing need to submit documents electronically, and we recognize that. The office is going to take a flexible approach to electronic signatures, not just during this period, but I think moving forward. So we will generally accept facsimile signatures, text string signatures that are also known as S signatures. Those have the format of sort of a slash, a type name, and another slash. Signatures known as click wrap, and secure electronic signatures, I think, which include DocuSign. In terms of this, I can't remember the name that you mentioned, Synography, or I'm not familiar with that format, but as long as it doesn't require some kind of like special authentication software for SIPO to open it up to make sure that we can see the signature, we would accept it. So that's some good news for the profession. I mean, we did, when we introduced the new rules in October 2019, significantly reduce the signature requirements, but this will further reduce the burden for applicants and for agents.
Okay. Time for maybe one more question. Hard to go through and pick which one. We recently filed some maintenance fees in March ahead of the original deadline for paying those fees. Once the SIPO website was updated to reflect the maintenance fee payment, the payment date was shown as April 1st, even though our payment received reflected the payment made in March. Do you happen to know whether this is a glitch in the SIPO system that SIPO is aware of?
Yeah, that was a glitch. So our programming, I guess during the testing phase, we had missed testing out what happens with designated days. And what it was doing was it was, even though we were receiving those properly on whatever date they were submitted, it was applying the extension under designated days to both the time limit for making that payment and when it was considered to be received. So I believe the plan of action for that was SIPO was going to contact those applicants that did receive those notices and I think issue corrections. I'm not 100% sure on that, but rest assured, if the fee was submitted on a particular date, that is the date of payment that's reflected in our system. And I think it was just in the notices that it was improperly reflected as being April 1st. Okay, great, thanks. Maybe one more question. If a request to withdraw a Canadian application was filed, will we receive a quick acknowledgement, as this cannot be checked on SIPO's website if the case is not laid open yet? This is a very time-sensitive issue of great consequence. Thank you. Yeah, of course. I recognize the gravitas of that request and the impact it would have of having the application laid open. We would urge you to make that request as soon as possible. So even though I mentioned that there is an extension to the deadline to make that request, if you do get very close to the 18-month publication date, it's impossible for SIPO to stop the publication. We are still processing correspondence, so if you are going to make that request, it's better to make it through an electronic communication through the general correspondence page. Try not to make that one on paper, because there is a slowdown in the speed of processing paper correspondence, and that just has to do with the number of people on site at SIPO right now. Okay, fair enough. Just to go back quickly to the regarding electronic signatures, we have a request for SIPO to issue a formal public notice outlining the new position regarding electronic signatures. Just for you to note, Craig. And I see that we're at 2:29. Yep, I acknowledge that. Okay, thank you. So I think we should probably stop there. I'd like to thank both Craig and Jenna for all of their efforts in putting this together. It was very
helpful, and I hope you all found it very informative. We also thank the audience for participating in today's webinar, and we invite you to complete the online evaluation form that has been sent via email. Thank you and have a great afternoon.